Yes. Good morning, everyone. Today, S.JAYALAKSHMI and myself, Advocate SRUTHI, will be before you for a short discussion on Section 230 and 66 of the Companies Act 213. Both are very significant and crucial sections when it comes to corporate restructuring. We know that Section 230 of the Companies Act deals with compromises and arrangements, and it provides for a way to restructure the entire operations of the company. It helps us to resolve financial issues and merge with entities with the sanction of the scheme by the NCLT. We know Section 66 of the Companies Act deals with reduction of share capital, whereby the share capital is reduced with the approval of the NCLT, and also at the same time ensures fairness, transparency, and balancing of the interests of the shareholders and creditors. Now, both the sections are indispensable when a company thinks about corporate restructuring. Both the sections become very important sections which have to be given a thought about. They help in restructuring while at the same time ensuring that the shareholders' interests are protected. Now, on this webinar, to deepen our understanding, today we will be analyzing firstly the procedural requirements under the Companies Act, what is the judicial oversight, and also discussing certain notable case laws which highlight how these provisions have actually been interpreted throughout this corporate journey and how they have been applied in practice. I shall be taking you over through the procedural requirements under both the sections before we head on to understanding the critical aspects which are intertwining both the sections 230 and 66. And that will be held by my dear friend S.JAYALAKSHMI. Now, before we move on to discussing about the provisions of the Companies Act, let us hear a few introductory lines from Dr. KSR, sir, so that the webinar is set into motion. Over to you, sir.
Very good morning, my dear friends.
Not able to hear. Oh, sorry, yes.
Very good morning, my dear friends. We can say good morning many times. It's a problem because in courts we use my lord and your lordship frequently with words less. Now, see this 230 and 66, whenever we discuss, my memory goes down the memory lane for at least 3 decades. That is the kind of practice and the experience which today also, if I am just looking at the 1913 Act or 1956 Act, 2013 Act, see how beautifully these provisions have been brought. And I always tell the scheme of arrangement is like writing a poetry. You have such beautiful opportunity to bring out scheme in the best interest of all the stakeholders, be it the creditors, be it the shareholders, be it the other stakeholders like the employees and others. We should always remember that in a scheme of arrangement, we cannot put different classes of people in the same bucket. I am reminded about an Andrews or Anders Cinemas case of UK long before, where they have given a beautiful denominator saying that unless they are able to be brought under a common system of evaluation, you can't put people under the same bucket or in the same class. See the age-old proposition. Fairness, equity, justification, protecting interests of everyone is the second important premise with which schemes are viewed. The third thing is that there should not be any camouflaging of the scheme. Fraudulent purposes should not be there. There cannot be serious contraventions, offences, prosecution, even though the 2013 Act brought Section 240, that is 240 of the Companies Act. Squeeze out provisions under 236 cannot be used in every situation unless it is preceded by already a scheme under which an acquirer or persons acting in concert have acquired at least 90%. Therefore, squeeze out is not a solution for every situation which is there. And sometimes, therefore, we need to move from 236 like the snake and ladder to 66 or go back to 230. In fact, I entertain nowadays a serious thought that 66 should be brought as part and parcel of 230 itself, so that the scheme of arrangement encompasses with it a plain and vanilla scheme of reduction of capital also. I have a lot of cases and illustrations which are very innovative and interesting. Some of them with my own experience from several high courts to the current era of tribunals. I will share a few of the illustrations at the end of the presentation. Now over to the presenters. Two young persons have joined here to share their illuminating thoughts, interesting provisions on the subject of 230 versus 66. Over to SRUTHI and Jayalakshmi.
Thank you so much, KSR sir. So let us start with section 230. Let us understand what its purpose is and what is the procedural framework. Before we move on to understanding the provisions of the Companies Act, let us firstly understand certain terminologies which we, on a day-to-day basis talk about, but we may not have given a thought as to what the term actually means. So let us start with what a compromise means. Compromise, by the definition of major law lexicon, defines it as an expression which implies that there is an existence of a dispute, that too relating to rights, and the compromise seeks to settle such a dispute. What is an arrangement? An arrangement is defined under the explanation provided under section 230, which reads as follows. An arrangement includes a reorganization of the company's share capital by consolidation of the shares of different classes, or by division of the shares into different classes, or by both the methods. So when we understand that arrangement mostly is talking about with respect to the company's share capital, and it can be by way of a consolidation of the shares, or it can be by way of a division of the shares. The next term is reconstruction. Reconstruction is generally done for the following purposes. That is, in order to raise additional capital, in order to reduce the share capital of the company, extending the objects of the company, or reorganizing the structure of the company, and also may be done for the purpose of securing some tax benefits. So when we talk about these three terms, we understand that compromise and arrangement is more of a tool for the purpose of doing certain reconstruction, or for the purpose of certain reorganizing the structure, or doing some reduction of share capital. This compromise and arrangement helps us achieve certain these things. So a compromise and arrangement may be proposed for the purposes of scheme of reconstruction, or the companies, or of the company or the companies, or an amalgamation of two companies. So under section 232, when an application is made before the tribunal under 230, we understand that the compromise or arrangement is being proposed for the purposes of reconstruction, or it can be for the purposes of amalgamation. And when we talk about 230, it is not just a compromise or arrangement which is involving a reconstruction or an amalgamation. It should also specifically include that there is something happening with regard to the property or the liabilities of the company. So the scheme will help us to do some alteration along with and the scheme should include the part of undertaking of the company, or it should include something to do with the property or liabilities. So generally under 230, we are doing both the reconstruction, we're doing both the amalgamation along with the undertaking of the company or property or liabilities, which are going to be transferred from one company to the other, or it's going to be divided among two companies. The compromise of arrangement, like I already told you, it is a tool for doing all of these actions. For example, for reduction of share capital, it will be by way of compromise or arrangement, or buyback can be by way of a compromise or arrangement, takeover of shares, merger, amalgamation, variation of shareholders' rights, or even cancellation of them, debt restructuring, etc. So to understand overall, we have the final dissection, which is compromise or arrangement becomes the overall tool under which you're doing a merger or an amalgamation or a scheme of restructuring. What is an amalgamation is not provided under the Companies Act. So we take a reference to the Income Tax Act, which section 2(1)(b), which states that amalgamation in relation to companies means merger of one or more companies with another, or merger of two or more companies into one company. And also merger is a defined, merger can be by way of two, which is merger by way of an absorption, or merger by way of a new company formation, which is also provided under section 230 of the Companies Act. The next thing is to understand what the 1956 Act has to say about the compromise and arrangements. So section 391 of the Companies Act provides for compromises and arrangement. It says that the company can enter into a compromise or arrangement with the creditors or with the members, and an application for this purpose can be made by the company, creditor, member, or liquidator. And just like the 2013 Act, it also says that majority representing 3/4 in value will have to approve the compromise and arrangement. But only two ways are there, which is they have to be present and voting. The next thing is that under the 1956 Act, it was the compromise and arrangement power vested with the Company Law Board, and the 392 section provided that the compromise and arrangement will be enforced by the High Court. And for the purpose of compromise and arrangement, the application will also have an affidavit disclosing certain very material facts, such as the financial statements of the company. It can include what is the auditor's report or even investigation proceedings. So this is what the 1956 Act has to say about compromises and arrangements. Now, what is the key difference between 1956 Act and the today's compromise and arrangement under 2013 Act? We have firstly understand that previously, before the Company's Second Amendment Act of 2002, which came into force on the 1st of January 2003, the company compromise and arrangements previously vested with the jurisdiction vested with the Company Law Board. And 392 provided that High Court will have the power to oversee and enforce the compromise and arrangement. The next thing is dispensation of meeting of the members with the which was vested with the High Court. We can see that as early as 1974, the Delhi High Court, in the case of Mazda Theatres versus New Delhi Bank of India, it said that the consent of shareholders, if it is given outside the meeting, then it is sufficient to comply with the provisions of the 391 and 392. The next difference that we see is that it specifically provides that there has to be an affidavit in case the compromise or arrangement includes a reduction of share capital. Another key difference is that the 2013 Act requires not just the auditor's report, but also a certificate from the auditor stating that, yes, Section 133 accounting standards are being complied with. Now, the next point of difference that we see is in the 1956 Act, in the previous slide, I have told that the meeting of the shareholders will be held by, the voting will be by people who are present and voting. But now under the 230 subsection 4, we see that a notice shall provide that the persons to whom the notice is sent may vote either through proxies, or there is a provision which enables postal ballot to the adoption of compromise or arrangement. So the Companies Act 2013 enables people to vote even by way of a postal ballot. Next is the compromise or proviso to section 234, which brings a threshold even for the people who want to object. Now there is a threshold which states that the compromise or arrangement shall be objected to only by persons who are holding not less than 10% of the shareholding. Now, in case it is a debt, it provides that they should be holding not less than 5% of the total outstanding debt as per the latest financial statements. Now, in case it includes a corporate debt restructuring, then a valuation report comes into picture under the section 230, under the provisions of the Companies Act 2013. Now, as we already understood what are the provisions with respect to compromise and arrangement under the 1956 Act, it would be easier for us to understand what the 2013 Act has to say. So firstly, Section 230 to 240 of the Companies Act 2013 deals with compromises and arrangement. It includes mergers, demergers, amalgamations, takeovers, debt restructuring, etc. And as already seen, it is a compromise and arrangement between the company and the creditors, or it can be between the company and the members. And approval is by 3/4 majority, and majority representing 3/4 in value of the creditors or members or classes of creditors and members. Now, the same way, the application will be made by the creditor, company, or the members, or a liquidator in case the company is going to be wound up and it is going through liquidation. Then the liquidator can propose the scheme of compromise or arrangement. Now, what are the other important provisions under 230 Act? Firstly, Section 230 involves 3 stages when your company is proposing a compromise or arrangement. There are 3 stages. First is the application stage, whereby you will be requesting the tribunal to order for a meeting of the members and creditors. Now, the second stage is the meeting in itself, which is the members and creditors will hold a meeting. The third is a petition stage when all of these formalities are over, the objections are taken into consideration, and the petition will be filed before the NCLT so that the scheme is sanctioned. So we understand that during this whole process, a notice has to be sent to all the creditors, notice has to be sent to all the members, debenture holders if there are any, and then there is an oversight by regulatory authorities, which is not just ROC, RT and SEBI. It includes income tax authorities. There is RBI coming into picture. There's stock exchange, official liquidator, Competition Commission of India, and other sectoral regulators will have a right to object to your scheme of compromise. So we see that there's an overall oversight about on the compromise and arrangement, and it includes regulatory and sectoral authorities as well. And as already stated, we do not just restrict ourselves to an auditor's report. We go ahead and get a certificate from the auditor stating that, yes, my scheme is in conformity with the accounting standards which are prescribed under 133. Now, specific provision for dispensation of the meeting has been provided under the Companies Act 2013, which is Section 213, subsection 9. It states that if at least 90% of the creditors or class of creditors in a class agree and confirm to the scheme by way of an affidavit, then the tribunal has the power to dispense with the meeting. So dispensation of the creditors meeting, as already stated, it is like power is with Section 239. It says that if 90% approve, then the tribunal can approve the scheme without the requirement of holding a meeting, and 90% must be by way of an affidavit. And there is no specific dispensation provided for the members under the Act. However, during the course of the journey, we have seen tribunals who have now granted the dispensation of even shareholder meetings on the basis of consent affidavits obtained from them. Now let us move on to what Section 66 and how it is intertwining with Section 230. Now, the explanation provided under 230 states that for removal of doubts, it is hereby declared that the provisions of 66 shall not apply to a reduction of share capital, which is effected in pursuance of an order of the tribunal under this section. So, we see that the reduction of share capital, when it is involved under the whole compromise and arrangement, when it's involved under an application which is made under 230, then you do not need to file a separate process under Section 60. Because a scheme of arrangement can include a reduction of share capital and thereby not requiring an independent compliance under the Section 66. Now, how was the position? Let us do a quick look back under the Companies Act of 1930 and the Companies Code Rules of 1959. Now, the very important judgment here is the Honorable High Court of Gujarat in the case of Navjeevan Mills, which is under Para 38. We are seeing that it says that Section 391 is a complete code which provides for sanctioning of the compromise or arrangement. If such a scheme includes an increase of share capital, it can be done by way of the part of organization of the share capital, which would be part of the arrangement. But if it is having a reduction of share capital in view of Rule 85, the procedure which is prescribed for the purpose of reduction of share capital, which is Section 100 under the 1913 Act onwards, will have to be gone through. So now we see a complete contrast which is between the 1913 Act and the 2013 Act, which says that when there is a reduction of share capital which is included and it forms part of the scheme, then there is no requirement. But under the 1913 Act, it states that even though it is a reduction of share capital, in view of Rule 85, the specific procedures which are prescribed for reduction of share capital will have to be gone through. Now, this is just to give a perspective of how much the Companies Act 2013 nowadays, what we are dealing with, has evolved. When we look at the technicalities, there are certain compulsory disclosures under Section 232, which says that by way of an affidavit, you need to disclose to the NCLT the following things: the latest financial position, if there are any material facts, the latest auditor's report, there is a valuation report is also required, the consent of 75% of the creditors, secured creditors, in case it involves a corporate debt restructuring, if there is pendency of any investigation or proceedings initiated on the Companies Act. And specifically, Section 232B states that if there is a reduction of share capital in your application which is involving a compromise or arrangement, and it includes a reduction of share capital, then there has to be a specific affidavit with respect to that. Now, let us move on to understanding Section 66 in a separate manner, in an independent manner. What is Section 66? What do you mean by reduction of share capital? So firstly, Section 66 is subject to confirmation of the tribunal. It involves that if you are reducing the share capital, then it has to be by way of a special resolution. You can reduce the share capital in a manner and in particular may alter its memorandum. Now, what is the need for doing a reduction of share capital? There can be various circumstances. Firstly, there can be an accumulated business loss, there is trading loss, heavy, capital expenses of the company, and the company is looking to do something to extinguish such a loss. So in that case, the reduction of share capital can be a solution. Next is assets of the reduced and doubtful value. The assets are the original capital of the company is being lost, or that it has more resources than it can profitably employ. Then in such a case, we look at reduction of share capital. The next scenario is that having a paid up capital, which is in excess of what the company wants. Even in that situation, then the companies can go ahead with the reduction of share capital. Now, what are the ways to reduce this share capital? Is that one, the paid up capital has itself not been paid. So what you do is you extinguish or reduce the liability of the share capital to that extent. Next is, in case it is a paid up share capital, then you cancel the paid up share capital, which is lost or it is unrepresented by the available assets. Or you can pay off the paid up share capital, which is in excess of what the company wants. Now, reduction of share capital does not mean that the entire paid up share capital has to be altered. It can be a selective reduction of share capital as well, in which the company can also decide to extinguish some of its shares without dealing with, in the same manner with respect to all the other shares in the same class. Now, with respect to selective reduction, etc., my friend Jayalakshmi will be dealing with that in detail. Now, let us go ahead to understand Section 66 provision in depth. Now we see that with regard to reduction of share capital, if there is an arrear in repayment of deposits, or if there is arrear in repayment of deposits and interest, then the reduction of share capital, the NCLT will not be able to approve it. So first, we need to ensure that the arrears and deposits and interest are paid off before the company decides to go on for a reduction of share capital. Now, like we saw in 230, that there are sectoral regulators who are being involved for an oversight. In a pure case of reduction of share capital, then only notice has to be sent to the central government, with the ROC, RD, SEBI, and its creditors. Now, Section 66(3) states that no sanction for reduction will be given unless you're complying with the accounting standards, and a certificate to that extent is provided by the auditor. Next is with respect to the creditor's consent. While Section 230, we specifically require the creditor's consent. Here, what the Act is trying to say is that the creditors, either consent can be there, or the company has, determined what is the creditor's liability and made some sort of an arrangement, and that has to be disclosed to the tribunal. So that is sufficient. Section 66 specifically states that the tribunal may, if it is satisfied that the debt or claim of every creditor of the company has been discharged or determined or has been secured or the consent is obtained, may order for confirming of the reduction of share capital. So there is no specific requirement that so and so percentage of the share creditors will have to approve the reduction of share capital. It is sufficient if the claim of every creditor is being taken care of by the company before it goes on for a reduction of share capital. Now, to understand what is the entire reduction of share capital in respect of the principles, we refer to the very important case law, which is the Reckitt-Benckiser case, which is by the Delhi High Court. The principles which can be distilled for the aforesaid judicial dicta are summarized as under. First one is that it has specifically held that, see, reduction of share capital is a domestic concern. So as long as the majority decision of the majority prevails, they have the right to go ahead for the reduction of share capital. When we talk about majority of a special, if majority by a special resolution decide to go ahead for a reduction of share capital, and you're saying that it is a domestic concern, we will not interfere in it. Only thing that we have to see is that it also has a right to decide how this reduction is going to be carried out. So only thing that we have to, the courts will see is that there is a fair and equitable transaction which is happening by way of this reduction of share capital. Like KSR sir mentioned, there should not be any fraud, or the intention of the reduction of share capital alone will have to be looked into to know that there is an, a fair and equitable transaction. There is a fair value which is going to be paid for the reduction of shares. Now, when I'm just reading the last two lines, which is when the matter comes to the court, before confirming the proposed reduction, the court has to be satisfied about two things. One, there is no unfair or inequitable transaction. And two, that all creditors who are entitled to object to the reduction have either consented to it or been paid or secured. So this is the entire principle which runs behind the reduction of share capital. Now, now that we have seen both the provisions, let us just, revise ourselves with regard to what is the exact difference between Section 230 and Section 66. Section 230 is a broader concept. It involves compromise and arrangement. It involves a scheme of reconstruction. It can be an amalgamation, merger, etc. involved. And we know that reduction of capital is only a focused provision, and it specifically deals with reduction of share capital. Now, the other point of difference is that the scheme of compromise and arrangement may always include a reduction of share capital to be part of its scheme, and the reduction of share capital can take place pursuant to the order of the merger or scheme. However, on the other hand, reduction of share capital, if it is on an independent basis, then the company has to follow the provisions of Section 66 individually. It has to be followed. Now, and under 230, we saw that there are different stages, there are different approvals which have to be required. For example, the board of directors will have to approve. There has to be a 3/4 majority. There is also a sectoral regulator coming into the picture. Whereas under Section 66, there is only a special resolution which is required from the shareholders, and it is sufficient when the creditors' claims are either consented to or if they have been determined. Now, you can just read through what are the other important differences. For example, no reduction shall be made unless the arrears in repayment are being paid off, and there is a certificate to the effect that accounting standards have to be followed. Now, before I hand over the presentation to S.J. ma'am, I would like to take everybody to 2-3 case laws which are specifically on Section 66. For example, this matter which is before your screen is the NCLT Delhi High Court matter, which is the Redford Shahjahan Properties Private Limited, in which we can see that the application is specifically under Section 66 of the Companies Act. We see that the application has been made for the purposes of reducing the share capital to so and so extent. And what is the reason provided under this special resolution is that it is in excess of what the wants of the companies are, and it is by way of setting off of the accumulated losses. And this is a specific reason provided under the application for going ahead with a reduction of share capital. So in this case, the NCLT being satisfied with the above reasons, and also referring to the important Reckitt Benckiser's case, which held that, see, the question of reduction of share capital has to be treated as a domestic concern, and therefore the decision of majority will prevail, and therefore the application has been allowed, and the capital has been allowed to be reduced to so and so extent. Now, the other important case law which I would like to discuss is the Aviate Networks Private Limited case, which is a case which is filed under Section 230 of the Companies Act before the NCLT New Delhi bench. This is a order delivered on the 15th of March 2023, and the company states that it wants to go ahead with a scheme of arrangement for the purpose of reducing the share capital and for the purpose of writing off the accumulated losses which are lying in the books of accounts, which is as against the paid-up share capital of the company. The rationale provided under the application is that the paid-up share capital is in excess of what the company wants. So such a reasoning provided under the application, we see that it is aligning with the reasons which are provided, ingredients which are provided under the Section 66 of the 2013 Act. So this application, the Honorable NCLT has specifically referred to the sections which is 230 to state that, see, 230 is and larger scheme. 230 of the Companies Act envisages the scope of a filing of a composite scheme, and it can involve two types of reorganization. It does not. In the specific case, we see that there is only a reference to reduction of share capital, but we do not see any transfer or vesting of properties or liabilities as is required under Section 230 and 232. And therefore, it does not relate to an amalgamation or merger or demerger, which is coming under the definition of 230 to 232. And therefore, the NCLT has, by way of, it has stated that by way of no legal interpretation, merely a writing off of the accumulated losses and paying off the share capital is required to be falling under the ambit of Section 230, 232, and the mandatory provisions of Section 66 has to be complied with. And therefore, this application under 230 was therefore dismissed, stating that the company is trying to file a Section 66 under the guise of 230. And the present application, being devoid of any merits, stood dismissed by the Honorable NCLT. I thank you everyone for the opportunity. Now let us go ahead and understand in depth about the case laws, which will be delivered by my friend S.JAYALAKSHMI. Yes, over to you. Yes.
Now moving on to the core topic of today's session, which is Section 66 and 230 face off. In a layman's view, that everyone will be thinking that what is there a confusion in first place? Like there is a separate section for Section 66 and there is a separate section for Section 230. There are two different sections for two different acts, and there is a separate provisions and procedures prescribed under the act. But what is in first place the confusion arises is in question. Excuse me for a moment. Yeah. Although there is a separate provision for both reduction and scheme of amalgamation and merger, though Section 230 has to be taken as a one window clearance mechanism circumstantially. But there have been specific remarks given in the section that if the scheme contains any transaction or condition for which any specific section has been given under the law, the same has to be added or not. For example, if we see Section 230 of 10, it says that if a scheme of compromise or arrangement contains some conditions with respect to buyback of shares, then it has to go through the route of section, the provisions and procedures prescribed under Section 68 of the Act, and not otherwise. Similarly, for accounting treatments, it says that Section 133 of the Act has to be followed. But the provisions referred to above till now clearly establish that the provisions of Section 230 have been well drafted and are totally in sync with all other related provisions given under the Act. But when it comes to reduction of capital, it clearly states that provisions of 66 shall not apply. Now, this raises the question in the mind of people that in case the scheme is carrying a condition of reduction of share capital, whether the conditions provided under 66 can be neglected, whether mere compliance with Section 230 will suffice a purpose. So this gives rise to confusion and this generates a two school of thought basically because of the interpretation given by the tribunals in different views. So the first school of thought says the reduction of capital is happening through the route of 230, then it has to completed by complying with the procedure and conditions stipulated therein. But what the second school of thought says is that the scheme of compromise or arrangement may contemplate the reduction of capital, and such reduction must be an inclusive part of such scheme, but not a sole objective of the application of Section 230 of the 2013 Act. Let us go to the NCLAT's view and see what they say and how this two school of thoughts arise in the first place. So, in our Systems International Limited, held by NCLAT by 2018, where basically the facts of the case is that the company has filed a Section 230 application for reduction of share capital. But the NCLT Delhi has rejected the application, stating that the scheme contemplating the reduction requires it has to go through the process of 230 and it cannot come here for synthesis. But the NCLAT held that reversed the order by stating that the explanation is mentioning about the non-applicability of Section 66 and therefore the application under 230 is fully maintainable and does not require compliance of Section 66. So what the NCLT held is that you definitely not have to go through the process of 66 for this because there is already explanation given under the Act. So you don't need to have go to Section 66, but you can file under Section 230 and it can be implemented too. Moving on to the next case, which is Brillo Alloys Limited, NCLAT. It is between the Brillo Alloys Technologies and versus the ROC Karnataka. The NCLAT held as follows. But what the NCLT held and why it has been rejected. The NCLT says that the NCLT rejected the application, stating that there is no law that can reduce a company. The company has to file a reduction of share capital only to the extent of setting of the accumulated losses. And also NCLT held that the non-promoter shareholders cannot be paid out of the securities premium account. And also it went on to held that selective reduction of capital is not permissible. These are all the propositions given by NCLT. I will come back to the NCLT proposition too. And also it held that it has to go through the process of 230. It cannot come under 66 because it has a numerous complexities and various propositions have to be held. So you have to go through Section 230. Maybe if you want, the company wants, they can file under Section 230, but not under Section 66 and dismiss the case. But what the NCLAT held is that there is no law that a company can reduce its capital only to reduce any kind of accumulated loss. There is no specific provision prescribed under the Act for that it can only file an application for reduction only for setting off of the accumulated losses. So this is what first held. Secondly, it says that securities premium account can be utilized for making payment to non-promoter shareholders. NCLT has dismissed the same, but NCLAT reversed that the securities premium account can be utilized for making payment to non-promoter shareholders. Further, it held that selective reduction of capital is permissible by referring to Sandvik Asia Limited, Honorable High Court. It says that in the light of aforesaid proposition of law, we can safely held that the selective reduction is permissible if the non-promoter shareholders are being paid fair value of shares. So the court went on to say that if the non-promoter shareholders are not having any problem, and if they do not raise any objections with respect to the fair price of the shares, then it is the domestic discussion between the companies, and necessarily the court should not interfere in the same. So in the present case, none of the promoter shareholders of the company have raised any objection with respect to the valuation of shares, and it is nobody's case that the proposed reduction is unfair or inequitable. So this is what held by the Brillo Alloys case. For the last proposition it made is that is most important one, the previous one. Brillo Alloys. The most important proposition held by Brillo Technology is that Section 66 of the Companies Act makes provision for reduction of share capital simpliciter without being it part of any scheme of compromise and arrangement. They said it can be useful if there are so many complexities. Also, if there is a selective reduction, it can be go through the process of 66, and necessarily the company do not have to file an application under Section 230. So this is what the Brillo Technologies case gives us the proposition. Now we saw what is Section 66 and what is Section 230. Also, we saw that what are the propositions given by the NCLT tribunal, and we saw the views of various tribunals that in some case they say that you can file an application under Section 66 for reduction. In some case, we see that if there is a reduction of share capital, you have to go through the process of Section 66 and you should not come under 230. So these are the two school of thoughts, and we see they say a different view, and we see a different interpretation by the NCLT and NCLATs. So moving on to the next topic, that there are various states of reduction we can see prevailing in the market as of now, and how the companies are utilizing Section 66 in various manners. The first thing is that in the matter of Reliance Retail Limited, held by NCLT Mumbai on 5th March 2024, this is basically a case of selective reduction, and the court has held the selective, approved the selective reduction of share capital. So the company wanted to reduce its share capital by extinguishing and cancelling the shares, and want to give exit to the non-promoter shareholders. This is what basically the fact of the case. The rationale for capital reduction is that the petitioner company's equity shares are being traded. It is an unlisted company, but its shares are being privately traded at stranded prices by some brokers or intermediaries for some increasing prices. So, with the new investors becoming the shareholders of the company, purchasing equity shares of the company, the petitioner company therefore contends that such trading without any price discovery is not in the interest of investors, and also it is detrimental to their interest. So, this is what they rationale for the capital reduction. The court went on to say that the selective reduction is allowed for giving exit to the non-promoter shareholders. So, this is one way of by giving assent to the Brillo Alloys case. There has been one more case which has allowed the selective reduction of share capital. Moving on to the next case, which is Simpson and Company Limited. This was discussed and welcomed by all the fellow seers and fellow members, that it is very welcoming decision, because it involves a scheme which is filed under Section 230, which involves both consolidation of shares and the reduction subsequently. Because of the consolidation, there was a reduction, so it was allowed with some modification. But the reduction was allowed with some modification. Why, let us see. So the company wanted to consolidate its paid up equity share capital of rupees 10 each into a share of rupees 2,500 each by consolidating 250 shares of rupees 10 each into one equity share of 2,500 each. So since the consolidation will result in infractions which will be paid off, excuse me. Since the consolidation will result in infractions which will be paid off, as a result, there will be a changing in voting rights. The why for the reduction of share capital, the company has, for Section 230, which involves a consolidation which consequently results in change in voting rights, and hence the company has filed a petition as required under Section 61(1)(b) to confirm such consolidation and the consequent variation of voting rights. Also, it results in reduction of paid-up capital. Hence, for a safer side, they have filed an application on IA for Section 66 also. But the consideration offered by the company is rupees 14,860 per share. But the minority shareholders have not agreed for that, and they have objected the share valuation. This is the main discussion before for this case, that the minority shareholders have never agreed for the price prescribed by the company, and they wanted to do a revaluation, and they do not want to allow this application. But the NCLT has held it is unable to find any inappropriateness in the valuation of 14,860 per share. The shares of the company do not carry any liquidity, and therefore cannot the taker of the shares, higher the price, higher will be the liquidity discounting factor. It also said to safeguard the interest of dissenting minority shareholders who are not willing to accept the offer consideration prescribed by the company shall create a trust in fractional shares which will be vested for benefit of dissenting shareholders. Basically, in this case, the court has allowed for consolidation of shares, and for the reduction of share capital, it has directed the company to create a trust for the fractional shares, and it shall be vested for the benefit of the dissenting shareholders. With this modification, the court has allowed the consolidation, and for the reduction, it has allowed with the aforesaid modification. With respect to the Modern India Limited, this is also one of the case which gives an opportunity to the non-promoter equity shareholders to give an exit from the company, and the application was also allowed. So basically, the selective reduction and giving exit to the non-promoter shareholders, it has been allowed by the NCLT and LAT we can see from these cases. With respect to IDBI Bank, where I have been highlighting this case is that this is basically a simpliciter Section 66 application for setting off the accumulated losses against the credit balance of the securities premium account. But the pre-shareholding and the post-shareholding of the post-shareholding pattern of the bank will remain the same. Though they do not want to change anything, they just want to accumulate set off the accumulated losses. So it was also allowed by the court. Moving on to the next case, Philip India Limited, held by NCLT Kolkata. Basically, in this case, the company wants to cancel and extinguish very minimal 3.87 total issued subscribed paid up capital held by the minority shareholders. So it want to give exit. Similarly, this is the case when here also the promoter group and the group companies of the company want to give exit to the non-promoter shareholders. But the problem for discussion here in this case is similarly the same valuation of shares. The valuation of shares for the petitioner's company is rupees 740 per equity shares. However, the minority shareholders derived the valuation which goes to rupees 4463 per equity share. So there is a huge difference between the petitioner, the company's valuation, and the minority shareholders valuation, which is 740 versus 4463 per equity shares. The difference in valuation of shares was a dispute and stated as unfair. So the issues framed by the tribunal is that whether for buying out of the shareholding of minority shareholders for under the Section 66, which deals with the capital reduction, can be invoked. Because previously we saw that giving exit to the minority shareholders was allowed by the court, but and the Kolkata NCLT bench has rejected this application, stating that in the given case there is no application of Section 66 in any way, and held that we do not find anything in the pleadings, not even in the written note, involving the circumstances mentioned in Section 66A or 66B of the Companies Act for purpose of invoking Section 66 for the capital reduction. So in this case, the court has dismissed Section 66 application for giving exit to the minority shareholders. Now we see the another case, which is a composite scheme of 230 and 66. In the matter of Azim Premji Trustee Company by NCLT Bangalore bench. This basically involves a composite scheme of arrangement for reduction, and they wanted to reduce the capital from 1 lakh to literally nil. So literally it is zero, and they wanted to convert it from a company limited by shares to a company limited by guarantee without capital. So this is a unique case which the tribunal has also allowed, but there was some objections by the RD and ROC side. So what it says is that there are no rules or regulations for the specified conversion of company limited by shares into guarantee. So under the Act, there is no provision for the conversion as aforesaid. The power to reduce the capital under Section 66 cannot be exercised by the company to reduce the paid-up capital literally from 1 lakh to 0. Such proposal is contrary to the provisions of Section 66 of the Companies Act. So these are the objections given by the RD and ROC. Further, it also says Section 18 of the Companies Act permit a company of any class registered under this Act may convert itself as of a company other class under this Act by alteration of MOA and AOA. This company has been registered as a company limited by shares. Therefore, the company limited by shares can be converted into company. So this was the objections given by the ROC and RD. What the court held is that the NCLT held that there is no such requirement that the company should hold at least a minimum of 1 share in case of company limited by guarantee. So the court says clearly that there is no need of holding a minimum amount of share capital in the company. I mean minimum 1 share for a company limited by guarantee. Further, it went on to say that though there has been no rules having prescribed so far for allowing the conversion in the reverse direction, the company limited by shares into company limited by guarantee, it does not mean that such conversion cannot be allowed when it is allowable under the provisions of Section 18. Excuse me. So the court has allowed the said application. So moving on to the next case, this is basically a recent case. Section 8 company. This is basically LBR Foundation as a Section 8 company, which was formed under Section 25 of the Erstwhile Companies Act. The company has received foreign contributions and share application money from its overseas parent company between 2010 to 2015. But it wanted to reduce the share capital because it has received the funds in the non-FCRA account. Basically, as per FCRA account, it has to receive the money through the FCRA account, but the company has received the subscription amount and allotted the share also. Because of the non-compliance of FCRA account, FCRA rules, it has to reduce the share capital and it cannot allot the shares because of the violation. So it wanted to return the money to the parent company. But the legal issues and regulatory violations stated by the RD is that the company has violated under Section 42 because the company has not allotted the shares within the stipulated time. Also, the company has received the funds through the non-FCRA account. So these are the violations stated by the RD. The court rejected the application for reduction of share capital, stating that the Section 8 company has to use a fund for the object it has been created, and it cannot use this reduction of share capital route to transfer the subscription amount to the parent company. So this was held by the LBR Foundation. So this is a case wherein this is the latest case wherein the Ulundurpet Express Highways Private Limited versus Regional Director. The reduction, this is also filed for reduction of capital, but this is a unique way of, and this is a different style of reduction of share capital, and the company proposes a unique way of reduction as it wants to return the capital to the shareholders. So UEPL is basically a toll-based highway company. It was operating, generating a surplus cash, but it could not distribute it as dividends due to accumulated losses. So to address this issue, what the UEPL is proposed is that the reduction of equity share capital by cancelling its 16.76 crore equity shares of 10 each. The cancellation was coupled with a plan. See how the company is planning is it wanted to repay the shareholders at the rate of 11.33 per share, totaling 1,900 crores, structured as unsecured loans bearing a 14% annual coupon rate. So they wanted to return the capital to the shareholders by way of unsecured loans at the rate of 14% annual coupon rate. So the NCLT, what it says is that it has rejected the application, stating that it does not satisfy the requirements under Section 66(1)(b)(2) of the Act. But the NCLT held noted that the reduction of capital was in compliance of Section 66 and emphasized that Section 66 of the Act permits a company to reduce its share capital in any manner. So the NCLT is insisting again and again that Section 66 can be filed in any manner, and it is a domestic concern and it can file it for any purpose it wanted to reduce the share capital. So thus, considering the above, the company has a power to reduce its shareholding pattern in any manner, this being a domestic issue. This was held in the Ulundurpet case. So moving on to the conclusion, I would like to state that if there is any inconsistency arises between two provisions of the Act, it is always recommendable to apply the rule of harmonious interpretation to give effect to the different provisions and to meet the real requirement and intention of the legislature. So in the case of above discussed situation, if we go by the first school of thought, it will not achieve the whole purpose of section 66. But on the other hand, if we go to the second school of thought, it seems to be more justifiable and purposeful sort of interpretation. So therefore, it can be concluded that reduction of share capital cannot be done under the shed of 230 of Act and section 66. The specific provision for the same has to be added until or unless such reductions forms an integral part of the scheme. So, and it is not the sole goal of such scheme. So thank you everyone for joining us today for the whole session and being patient for the same. And if there is any doubts or queries, you may please raise your hand. It will be answered one by one. Also, I request Dr. KSR sir to address the same. Thank you all.
Yeah, SRUTHI and Jayalakshmi, both of you have presented very elaborately. I believe all the aspects of the scheme were brought for discussion. I really appreciate the efforts you have made in relation thereto. As I said in my introductory remarks, I wanted to share certain experiences in this field. Of course, we were not part of the 1913 Act. We came into picture in practice only from the 1994. In 2004, a scheme was drafted by me between two wholly owned subsidiaries of a foreign company. One WOS was operating from Tamil Nadu and another was operating in Delhi. The Delhi company was not doing any operation, that there was a cash reserve available in the Delhi company. And this cash reserve was required, and therefore they have transferred it by way of loan to the Tamil Nadu company. The parent is safe. And in this scenario, we advised a scheme of amalgamation, resulting in the Delhi company becoming transferor and the Tamil Nadu company becoming transferee, whereby the entries contra will go off. As I told you in the beginning, it is like imagination, creativity, poetry, whatever you want, you can do it. All that you need is a sharp pencil and a sharp mind. I did this in 2004, and Delhi High Court changed the appointed date from 1/7/2004 to 1/4/2004, just 3 months before, to align with financial year commencement. Therefore, we have to come back to the Madras High Court and ask for a change in the modification in the scheme, quoting the Delhi High Court order. We made an application and got the appointed date corrected, modified, so that the scheme could be implemented. 2004. All these things will tell you that in relation to these matters, you have many objectives which can be achieved. Reorganization, restructuring, compromise, arrangement, anything. And all that you need to see is it is within the plastic framework of, or flexible frame. Plastic is not a good word nowadays. So flexible framework of the 230 of current day. Let me go back again to some yester era, 2006, in relation to another scheme of arrangement which I moved before the Andhra Pradesh High Court, the unified state that time. In this case, I used the benefit of section 140 of the Indian Contract Act because it was a listed company, it was a loss-making company, shares were not trading. We cannot say even infrequently trading because nothing is happening in the company. And bankers were pressurizing, promoters had to bring money, pay off as guarantors the amount due to the secured creditors. And using the provisions of the Contract Act, rights get invested in the promoters' guarantors, and therefore guarantors were treated as secured creditors. And a scheme of reduction of capital and arrangement was devised. I wrote it by hand, whereby the 10 rupee shares were reduced to 1 rupee share, whereby almost like 5.8 crore or something was written off against the losses. And the secured creditor or the promoter who have become the secured creditor, stepping into the shoes of the secured creditor as guarantors for their 1 crore 4 lakhs or something, we used the reverse issue of shares. So it was a combination of reduction as well as increase in capital. And this scheme had difficulties in the stock exchanges because the Bombay Stock Exchange was in dialogue with me to understand what can be done in a scenario where there is no price and how can you fix 1 rupee as the relevant price because share capital is under the scheme reduced from 10 rupee to 1 rupee. All shares reduced. So 6 crore 2 is becoming 62 lakhs only. Therefore, I gave a proposal to the Bombay Stock Exchange for their NOC. I'm talking about 2005-6. And that proposal was again accepted by the stock exchange that we will allow the scheme to happen. We will allow the scheme to sink. Let the dissemination take place. Within 90 days, we will find a date after the scheme is sanctioned, after the scheme is implemented, a preferential allotment at a discovered price will be made, whether it is 1 rupee or more than 1 rupee. If it is less than 1 rupee, I will commit 1 crore 4 lakhs at 1 rupee. If it is more than 1 rupee, I will issue shares at that price. We will give a 90-day settling time. Basis that NOC, we moved the Andhra Pradesh High Court, asked for a modification. In 2005-6, I am talking about. We made the reduction of capital with a combination of scheme of arrangement, which I still remember all the way from Delhi or all the way from Andhra Pradesh. People have asked me to draft the scheme. Let me take you back to when S.J., we call her S.J., S.JAYALAKSHMI, when she was talking about this Ulundurpet case of January 2025, let me tell you, 2009, Kerala High Court, 2 schemes. I have to explain how it should be presented. The capital required was only 3 crore. The company had 30 crore capital. So we reduced the capital. I wrote the scheme saying the entire money will not be returned, will be retained by the company by way of unsecured loans and will be settled over a period of 5 years with 18% interest. Kerala High Court in 2009 sanctioned the scheme. Al-Ahali Business Solutions or something is the name of the company. And even recently, if you look at the NCLT order in Spark Capital case, it's a combination of reduction, increase, merger, demerger, cancellation, selective cancellation of certain shareholders. It's a comprehensive, illustrative scheme which was presented by us. Therefore, in this provision, 66 versus 230, different facts require us to think differently and see whether we are going to fit within the narrow bandwidth given by 66. And if it's slightly transgressive, better to go under 230. Forget the day the NCLT Delhi bench saying you should have come under only 66, you have come under 230, therefore I am not going to consider it and all. Maybe there are odd benches, odd decisions, and that is a different thing altogether. That is probably a part of the journey which we have to do from the time we think about or conceive about the scheme of arrangement or scheme for reduction of capital, pure and simple. All that I want to say is, I think, given the experience, we should be able to recommend that this 66, already, of course, the explanation is there. In one of the cases, the explanation was read out, and NCLT has missed the explanation. NCLAT has noted. In fact, there was one case where in NCLT has talked about clarified about these kind of matters. See, therefore, if 66 is brought as part and parcel of 230 only, we don't need one provision, we don't need a new procedure. Anyway, special resolution and confirmation with objection, notice to shareholders, creditors and whatnot is happening. Anyway, valuation is there. So bring it under 66 can be brought under 230 itself is probably one suggestion which can be considered by the department, ministry. Of course, it is a parliamentary thing and the reduction of capital is not a new provision. Like compromise arrangement, it is also 100-year-old in our country. You take, I can say 110 because 2013 and now it is 10 years or over. So it's a beautiful opportunity and I appreciate both of you for bringing to discussion very, very interesting points, interesting dimensions. And I look forward to, if there are any queries, if there are any questions, if somebody wants to offer clarifications, another 2-3 minutes or 5 minutes we can spend before we call it a day. We thought it fit to have it on working day because it is a very important program and we don't want to be relegating this kind of a very valuable subject to a holiday mode. Because this is absolutely a very interesting topic and every day it is happening around the country, even elsewhere. Over to participants. If they have any questions, they may raise their hand and our friends will handle it. Thank you. Yeah, Shruti, we can call it.
I don't think there are any. I don't think there are any queries, so I think we can call it a day. Thank you. I thank you so much for providing us an opportunity to learn about these sections. I thank you, everyone, for joining the webinar. Looking forward to having such opportunities in the future. Thank you, everyone.
Thank you.